Let me tell you something. In all my years working in immigration law, I have not seen a month of April quite like this one. And I mean that. Whether you're a green card holder, an employer, an asylum seeker, or someone who entered through the CBP One app, April 2026 is bringing real tangible wins that you cannot afford to sleep on. I'm going to walk you through 4 specific groups of immigrants who right now, today, have opportunities available to them that simply weren't there before. And not only am I breaking this down as an immigration attorney, I'm sharing it with you as someone who has personally lived this journey, someone who has gone through the process, filed the petitions, waited on the bulletins, and understood what it feels like to finally see your category become current. So if you or someone you love falls into one of these 4 groups, stay with me until the very end, because this information could genuinely change the direction of your case. Let's start with the first group. And honestly, this one alone is reason enough to make this video: green card holders. If you are a lawful permanent resident and you have a spouse who is currently inside the United States in lawful status, I need you to pay very close attention right now. The F2A visa category, which is the category specifically reserved for green card holders petitioning for their spouses and unmarried children under 21, is now current. And I want you to understand what that actually means, because it's a bigger deal than it might sound on the surface. Normally, when a green card holder files a petition for their spouse, there's a waiting period. You file, a visa number gets assigned, and then you wait, sometimes months, sometimes longer, before that number becomes available and your spouse can actually move forward with adjusting their status. That wait has been the frustrating reality for so many families. But right now, in April 2026, that wait is gone. The USCIS category is current, which means the process can move forward almost immediately in a way that was previously only possible for U.S. citizens petitioning for their spouses. This is genuinely extraordinary. And it's not just good news for green card holders in general. It's specifically big for nationals from countries like India and China, where visa backlogs have historically been brutal, stretching years and in some cases even decades. Those backlogs have caused immense pain and separation for families, and seeing the F2A current for all countries is something I haven't been able to say in a very long time. So if you are a green card holder and your spouse is here legally, whether that's on a work visa, a student visa, or even a visitor visa, now is absolutely the time to act. File that I-130 petition and that I-485 adjustment of status application. Do not wait. The Visa Bulletin can shift from month to month, and there's no guarantee this window stays open. But right now, today, you have the ability to file as though you were a U.S. citizen, and that is not something that comes around often. Of course, the key requirement remains: your spouse must be in lawful status. If they entered without inspection or have any period of unlawful presence, that changes things significantly, and you'll want to consult with an immigration attorney. But for those who are here legally, this is your moment. Now let's move into the second group, and this one is going to be big news for both employees and employers alike. The EB-2 employment-based second preference category is now current. For those who aren't familiar, the EB-2 category is for immigrants who are being sponsored by an employer based on their advanced skills, professional expertise, or in some cases, extraordinary ability in their field. This could be scientists, engineers, researchers, medical professionals, highly specialized workers, people whose knowledge and talent genuinely benefit American businesses and the broader economy. And right now, visas in this category are available. There is no backlog holding you back from moving forward. What does the EB-2 process actually require? First, the employer needs to extend a formal job offer to the immigrant employee. Second, they need to go through the PERM labor certification process. This is the step where the employer demonstrates that they've genuinely tried to find a qualified U.S. worker for the role and were unable to do so. And third, the immigrant worker needs to show that they bring real value to that position, whether through an advanced degree, a bachelor's degree combined with substantial progressive work experience, or in some cases, through a national interest waiver. The exciting part right now is the timeline. Because the category is current, once an employer files the I-140 immigrant petition and it gets approved, the employee can file for their adjustment of status and potentially receive their work permit within 3 to 4 months. That is an incredibly fast track compared to what we've seen in recent years. And importantly, the EB-3 category, which covers skilled workers, professionals, and other workers, is also current right now, giving even more people access to this opportunity. If you're an employer who's been holding off on sponsoring a talented foreign national worker because you didn't want to deal with long waits, this is your sign to move forward. And if you're an immigrant worker who has been hoping an employer would sponsor you, now is the time to have that conversation. Approach your employer, explain the current state of the Visa Bulletin, let them know that the process is moving faster than it ever has, and make the case for why now makes sense. Because right now it genuinely does. The third group of immigrants who have a significant development this April are asylum seekers. And this one has been a long time coming because asylum processing had essentially been brought to a standstill for quite a while. The uncertainty, the silence, the not knowing, that has been the reality for hundreds of thousands of people who came to this country fleeing genuine danger, genuine persecution, and genuine fear of returning home. But here is the update. The Trump administration has announced that they are resuming processing for asylum seekers who are currently inside the United States. Now, as with almost everything in immigration right now, there is an important condition attached to this. The resumption of processing applies specifically to asylum seekers from what the administration is classifying as low-risk countries. High-risk country nationals are not included in this particular resumption, and the administration retains the authority to determine which countries fall into which category. Additionally, all applications going through this process will be subject to screening and vetting before they move forward. But here is what matters. Processing is happening again. And for people who have been in limbo, who filed their asylum applications months or even years ago and heard nothing, that is meaningful news. If you are an asylum seeker and your application has been sitting out there, this is the time to take a hard look at what you submitted. A lot of asylum cases, and I say this from years of experience sitting across the table from clients, are won or lost, not just on the facts of what happened to someone, but on how well those facts are presented, documented, and testified to. If you filed what I would call a bare bones application, meaning you put something in just to get the clock started, but didn't include detailed affidavits, country condition evidence, supporting documentation, or a thorough personal statement, now is the time to strengthen that case. Get a strong affidavit written. Pull together current country condition reports. Document your membership in a particular social group, your political opinion, your religion, or whichever protected ground applies to your situation. Show clearly that the harm you suffered or fear you have is real, that it is connected to one of those protected grounds, and that your home government either participated in that harm or was unable or unwilling to protect you. Those are the pillars of a strong asylum case, and credibility runs through all of them. How you tell your story matters enormously. So use this window wisely. Don't just wait for your interview to come around. Prepare now, while there is still time to build something solid. And that brings us to the fourth and final group, and this one involves a federal court ruling that directly affects approximately 900,000 people. So if you or someone you know entered the United States through the CBP-1 application during the Biden administration, please pay close attention. Under the previous administration, the CBP-1 app was used as a legal and authorized pathway for migrants to schedule appointments at ports of entry, be screened and vetted, and then be paroled into the United States. These were not people who snuck across a border. These were individuals who went through an official government process, were reviewed, and were granted lawful parole status to enter and remain in the country while their cases were processed. When the Trump administration took office, many of these individuals received letters telling them their parole had been revoked and that they were required to leave the country. Some were even deported. The fear and confusion that followed for those 900,000 people was devastating. But a federal judge has now stepped in and ruled that the revocation of those parole statuses was unconstitutional. The court's position is that these individuals had lawfully obtained parole, that it cannot simply be stripped away without due process, and that their status needs to be reinstated. This is an enormous legal development. It means that if you entered through CBP-1 and you have been hiding, afraid to leave your home, afraid to go to work, afraid to make any move because you thought your status was gone, you need to know that a federal court has recognized your right to be here. Your parole status should be reinstated. And beyond just the immediate relief of knowing you're not subject to immediate removal, this ruling opens doors, because with a valid parole status, you may now be eligible to pursue other immigration benefits. If you have not filed for asylum and you have a legitimate fear of returning to your home country, this may be the time to explore that option. If there are other pathways available to you based on your family situation or employment, those conversations are now possible in a way they weren't when your status was in question. So let's bring this all together, because April 2026 is genuinely one of the most active and opportunity-filled months in immigration that I have seen in years. Green card holders can now file for their spouses almost immediately thanks to the F2A category being current. Skilled workers and their employers can move forward with EB-2 and EB-3 petitions right now with no backlog standing in the way. Asylum seekers from low-risk countries are seeing their cases move again after a long and painful freeze. And nearly 1 million people who entered legally through CBP-1 have just received a federal court ruling that protects their right to remain. These are real wins. They require real action. And the window that exists right now may not stay open forever. If you fall into any of these 4 categories, do not wait. Talk to an immigration attorney, gather your documents, understand your options, and move forward. Share this with anyone in your circle who might need to hear it, a family member, a friend, a coworker, because the time to act is absolutely right now.